back to podcast 2 in our interview with Judge Johnstone. In this podcast, we're going to look at the structure and processes of the Children's Court. How did judges get to areas where there are no designated courts for children?
Well, the President and 7 of the children's magistrates are permanently located at Parramatta. We have 2 children's magistrates permanently located at Glebe, that's Badura. And we have another magistrate at each of Broadmeadow, Woy Woy, Port Kembla and Campbelltown. The magistrates at Broadmeadow, Woy Woy, Port Kembla and Campbelltown also service the surrounding districts, so that, for example, the Woy Woy magistrate also goes to Wyong for a day a week, and the Port Kembla magistrate goes to Nowra for a couple of days every fortnight. Specialist children's magistrates also sit regularly at circuit locations in other parts of the state. The Children's Court now effectively operates 4 country circuits, pursuant to which magistrates hear cases at specified country locations. They are the Northern Rivers Circuit, the Mid-North Coast Circuit, the Dubbo Orange Circuit and the Riverina Circuit. In addition, there is a country care circuit roster which details the standard sitting arrangements for these regions, and they include other places such as Bourke, Kempsey, Orange, Griffith, Albury, Wagga, Port Macquarie, Coffs Harbour and Lismore. The President and the Children's Magistrates regularly visit other country locations to hear cases on an as-needed basis, pursuant to the operation of what's called the Country Assistance Protocol. Under this protocol, local courts are able to seek the assistance of the President to allocate a children's magistrate to hear complex cases that require specialist knowledge and experience, or matters that are likely to exceed time standards, or matters that require a lengthy hearing that might otherwise disrupt the local list. We also have a capacity for audio-visual links, digital recording and telephone conferences that allows the court to deal with cases in the one location more efficiently, or sometimes, as we do, to have a matter dealt with at 2 locations where parties or practitioners might be at the 2 locations. For example, tomorrow I'll be hearing a case in Sydney in which some of the practitioners and parties are based here and some of the others are based at Woy Woy. Thus, some 80% of care cases now in the state are dealt with by the President and the specialist children's magistrates. That only leaves 20% of cases that are conducted by local court magistrates who exercise children's court jurisdiction. These cases are generally in remote locations, in places such as the ones I haven't mentioned previously. We also have a process whereby newly appointed magistrates who come to the local court spend 3 months rotating through the Children's Court at Parramatta to get some feel and understanding for the specialist jurisdiction before they go out into these country locations to serve their time in the local court.
How does the Children's Court differ to mainstream courts?
We differ in a number of ways. So far as care proceedings are concerned, it is a requirement that they are to be conducted with as little formality and legal technicality as the circumstances permit. Furthermore, the proceedings in the Children's Court are not to be conducted in an adversarial manner. Thus, the Court is both empowered and required to proceed with an informality and a wide-ranging flexibility that might be thought not entirely appropriate in some of the more formally structured courts, and this means that common sense fairness is applied in the particular case. Because the proceedings here are not adversarial, the parties are expected to be open and transparent, so that, for example, it would be inappropriate to hide a relevant document or to ambush a party with material that had not been disclosed as part of a pre-trial procedure. Furthermore, the Children's Court is not bound by the rules of evidence, unless it so determines, and that doesn't happen very often. This means that the Children's Court can and often does admit evidence that might be excluded in a criminal case, such as hearsay evidence or secondary evidence, such as a copy of a document rather than the original. The Court is also much more relaxed about the way in which evidence is presented, and in affidavits will often accept material that is in a narrative or otherwise inappropriate form, or is in the third person rather than in direct speech terms. Also, the court is more prepared to allow evidence even if the author of the document is not available to give evidence or to be cross-examined about the document. But that might mean, for example, that the document is then given less weight than it might otherwise be given. This might include, for example, a medical report where the doctor does not appear personally to be cross-examined. Care proceedings are conducted in a closed court, and the name of any child or young person involved or reasonably likely to be involved, whether as a party or as a witness, must not be published. This publication prohibition extends to the publication of any information, a picture or other material that is likely to lead to the identification of the child involved.
Can you briefly explain what alternative dispute resolution processes are?
Yes, in the Children's Court, over the past few years, we've initiated an entrenched and alternative dispute resolution process in care cases, principally through the mechanism that we describe as a dispute resolution conference, or a DRC. The DRC is an informal meeting conducted by a trained and experienced children's registrar. The usual DRC runs for around 2 hours, and each of the parties attends together with their legal advisor. The role of the children's registrar is both facilitative and advisory. The process involves what is a pre-trial, less formal opportunity for parties to reach an agreed position in relation to their dispute without the need for the formal hearing. Due to the confidential nature of the DRC, those involved can more readily state their position and place before the other parties what their position is in an informal way, and also in a less rigid, intimidating environment than the formal final hearing would be should that become necessary. This mediation process has brought about a significant cultural shift that has impacted on cases in the Children's Court. A recent independent evaluation has found high levels of participation and satisfaction. Family members involved have generally found the process to be useful, and they felt they were listened to and treated fairly. Approximately 80% of these mediations have resulted in the child protection issues in dispute being narrowed or resolved.
That concludes our examination of the structure and processes of the Children's Court. In the next podcast, which is part 3 of the series, Judge Johnston will discuss Aboriginal and Torres Strait Islander cases in care proceedings.